So is it possible to successfully respond to a money claim? Yes. Let's face it, no one wants to find themselves in debt, or worse still, an illegal dispute over unpaid debt. But if you do, there are steps that you can take to deal with it. Firstly, before any court action's taken, you'll receive a letter from the creditor outlining the amount owed and how it was calculated. They should also provide an information sheet where you can seek free and independent advice. This letter is known as a letter of claim, and you should receive it before any court action's taken. If you receive a letter of claim and agree with the amount owed, you can fill in the reply form provided and send it back to the creditor. Make sure to include your offer of payment and a copy of your completed statement of means form, which shows your income, expenditure, and any other debts you have. You can also request more information if you're not sure about the debt. It's important to reply within 30 days of the date on the letter of claim. If you don't reply, the creditor can ask the court to increase the amount owed. If you can't come to an agreement with a creditor, they should provide you with at least 14 days' notice before they start court action. But don't panic, it's unlikely that you'll have to attend court. Most of the process is done by completing court forms and sending them through the post. If you do receive a county court claim form, which outlines the amount owed and the details of the debt, you should respond within 14 days. You have a few options here. You can admit to owing the debt and offer a payment plan, admit to part of the debt and dispute the rest, or dispute the debt entirely. If you agree to pay the debt, make sure that you fill in the admission form with your offer of payment and the statement of means form. If you dispute the debt, seek legal advice before you respond, as the rules can be complicated. Remember that the court is not there to judge anyone guilty or innocent, but to settle disputes about money owed and how to repay it. If you're told to pay more than you can afford, you can ask the court to reconsider your offer. If you agree that you owe the debt, there will be a reply form with the claim form for you to make your offer of repayment. This is known as the admission form, or N9A. The form looks like a personal budget form and requires information on income and essential outgoings. There's also a section where you can list all of your credit debts and any other court judgments and the payments you make on your priority debts. It's essential to fill in the form and send it back to the creditor, called the claimant, at the address for service, which is mentioned at the bottom of page 2 on the claim form. Keep in mind, there's a 14-day time limit from the date the claim is served on you to send back the form. So this means that the document has been delivered correctly. If you don't send the form back, the court will enter the judgment against you and order you to pay the whole debt in one lump sum immediately, or what's known as forthwith. To make sure that your form reaches a creditor, I'd personally send it through recorded delivery and keep a copy. Also, it's crucial to make an offer of payment on the form. If you leave it blank, the court will assume that you haven't made an offer and will order you to pay the whole debt at once forthwith. If you're dealing with a debt that's in joint names, a creditor may send out separate claim forms to you and the other person liable for the debt. You'll both need to fill in separate reply forms and put an offer of payment in the offer of payment box on each form. If you've worked out offers of payment to creditors, put half of the offer on each reply form and enclose a budget summary and list of creditors. Explain what you've done in section 11 on each form. Once you send both forms back, the creditor will accept your offer and you'll receive a county court judgment CCJ from the court telling you to pay in monthly instalments. However, if the creditor doesn't accept your offer, the court will decide what you should pay each month. If you can't afford what the court has decided you should pay, you can apply to the court to look at your offer again. This is known as redetermination. There's no fee for this, and you can do this within 14 days of getting the order by writing a letter to the county court, quoting your case number. Attach your budget summary and explain why you disagree with the order the court's made. When it comes to paying, you should send your payments to the creditor, not the court. Keep a record of what you've paid and when, and you could ask the creditor for a payment booklet to make it easier to pay, or set up a direct debit or standing order. If you're struggling with debt beyond the court fines, you might consider exploring debt solutions. Some of these options can reduce your monthly repayments, while others may even cancel some of your debts. The solution that suits you best depends on your financial situation and your eligibility. Now, below this video, there's a link to a form on my new website. It gives you a few multiple choice questions like how much debt do you owe and how many people do you owe? And then at the end of that form, it'll connect you to a company that I've partnered with to give you all the information that you need about debt solutions. So click the link below the video, go and check it out and let me know how you get on.